The crime of aggression includes three components. I'll tell you about those now, and then I'll start to tell you about the repercussions, and then I'll end my presentation because I don't have that much time left. And if you have questions, then I can speak to the audience or speak to you after. The crime of aggression includes three components. There's the state act of aggression. That's the act of collectively waging a war or an armed attack, as it's being defined now, against another state or the sovereignty of another state, for instance, attacking the armed forces. This component is based upon a quite brilliant, subtle 1974 definition of aggression that came out at a détente during the Cold War, which is Escher-esque in its properties. Just like the artist Escher drew paintings where looked at one way, you could see it in a certain form, and looked at another way, it looks completely different. For instance, if you look at the Washburn School of Law symbol, you'll see the W. If you look at it one way and the scales in another way, the 1974 definition uses the same properties, where it contains the Soviet model for what a just war, what a legal war is, and the American model at the same time. And it's not indeterminate. It's determinate, but in one of these two ways. So that's the basis now for the crime of aggression. Okay? When you take out single provisions, it alters the entire meaning of this. So it's a very subtle discussion about what it means to modify this crime. That's one of the components that's being debated now in the special working group on the crime of aggression. The second part is the link between the individual and the state act. This is the question that Hannah Arendt posed in her book on Eichmann. How do you hold an individual accountable for the collective act of an entire society or military apparatus? This link is now being debated as well, and one of the components is the leadership criteria, the leadership component, that only individuals in a leadership position are going to be held accountable for the state act of aggression. That seems to be clear from the negotiations. But what does it mean to be a leader? Which is an interesting question today when bureaucracies are being replaced by networks. The third and most controversial element of the crime of aggression, the part that the United States is most interested in now, as is Russia, China, the UK, France, is the jurisdictional trigger. Should the Security Council have the right to trigger the case, have the responsibility to trigger, to have an on-off switch on aggression cases, so that before the International Criminal Court, an independent judicial body, can proceed, the Security Council needs to give the go-ahead. This is the most contentious aspect of the definition of aggression, and it's the aspect that I'm going to be discussing in the coming week in the Netherlands as the next session of the negotiations resumes. There's a bunch of gray area proposals that try to balance the interests of the great powers versus the majority of the Assembly of States parties, and it's possible that there's going to be a resolution in 2010 of this question. I think, am I up to my 10 minutes yet?
About there.
Okay, I'm about at the end of my time. So if you want to ask me about the repercussions of this definition on our understanding of which wars are just and which wars are unjust, then we can do that in the question and answer period. In the meanwhile, thank you very much for hosting me.
I'm going to use the prerogative of the moderator's chair to ask one or two questions that I just noted, really, in listening to your remarks, and then please prepare to have some of your own. You should have some good ones in light of these stimulating comments. Professor O'Connell said, I think provocatively and eloquently earlier, that under the jus ad bellum, our response to September 11 ran into serious difficulties because it wasn't the government of Afghanistan that was responsible. I want to ask first Professor Fletcher and then Professor Washburn if you agree with that assessment, and then second, if we were in violation, of international law in that respect, what were our options that would have complied with the law? And then Mary Ellen, would you please respond?
Okay.
Well, this is a difficult question for me because I don't have, it's difficult because there are cases involving the use of defensive force against aggressive organizations, the ones that come to mind most immediately about Israel. So I have a lot of sympathy with Israel's defense against non-state entities. Now, I know it's not entirely clear to me, first of all, in the case of Afghanistan, you can argue both ways. First of all, that the government is indirectly responsible for the existence of the Taliban. And secondly, that the government is involved in this way. But beyond that, why it is that the government has to be the author of the attack is not entirely clear to me. The purpose of the use of defensive force was to eliminate the Taliban. That always seemed to me a fairly easy case compared to the situation in Iraq. In any way, maybe you challenge me further on this.
Good.
Sorry, I was thinking of something else. Did you ask about Iraq or about Afghanistan?
Afghanistan.
Okay. I think the war in Afghanistan was legal. I think the war in Iraq was illegal. And I think that I need to qualify my comments by saying this discussion is a front in the battle for the constitutive rules of statecraft that I'm going to flesh out in my presentation tomorrow a little bit more as well. It matters how you see international law, how you evaluate these conflicts, and there's a debate now which is taking place at the more general level about the nature of international law, whether it's a centralized system, whether it's a disaggregated system, in how you evaluate these two wars. So I'll leave it at that.